From 1949, 23rd December, the idols were there in the structure. 6 December 92, the structure was pulled down, and then there was a temporary tarpaulin sheet structure, which was a temporary temple was built, and which the idols were kept. So, to move or replace those tarpaulins which getting torn by wear and tear of weather were also strictly controlled by proceedings before courts. Two different faiths where two different systems of their own theological identity of properties and concepts are at contest in a court of law. One thing stands established, that it was not a vacant land. Chapter 4 of the ASI report deals with structures. A significant aspect of this chapter is section titled The Massive Structure Below the Disputed Structure. Finally, the ASI concludes by indicating that now viewing in totality and taking into account the archaeological evidence of a massive structure just below the disputed structure are indicative of remains which are distinctive features found associated with temples of North India. Sri Gurubhyo Namah. Good evening, everyone. I've been asked to present the pleadings, evidence and arguments which were presented in the court which led to the construction of the temple in Ayodhya for Sri Ram Lala. Insofar as this case is concerned, my talk I would like to present it in a broadly, as the title goes. I'll try to place the pleadings, the evidence, the arguments and the verdict. So this is what actually goes into any adjudication under the Indian Constitution or any common law courts. People file a petition in the court, they lead evidence in support, and then there are arguments, and then there's an adjudication on the basis of the pleadings and the evidence which has been brought on record. In this case, the pleadings. So the first pleading, as you see, the left hand top of the screen is 16 January 1950. That is when this legal battle commenced. So, contrary to the perception that has been created amongst the public at large, that this is an issue which has cropped up sometime in mid-1980s by a political movement initiated by the Vishwa Hindu Parishad, the facts are to the contrary. The first suit has been filed on 16 January 1950 by Sri Gopal Singh Visharad. This suit is a result of the installation of the deity of Ram Lala under the central dome of the structure which existed on the site in the intervening night of 22nd and 23rd December 1949. So the installation happened prior to the constitution coming into the force, and then the suit has been filed. As you could see, he was a worshipper who wanted his right of worship of his deity Ram Lala to be permitted, and then the prayer he sought was declaration of his right to worship and have darshan as per the customs and traditions. And he sought a permanent and perpetual injunction restraining the defendants, the local Muslim population, a few of the prominent members, and the state administration and the district administration are shown as defendants in this suit, from removing the idols of the deity and other idols from the place where they were installed, and from closing the way leading to the idols. So therefore, the injunction suit has been filed, and the injunction was instead granted, in fact, incessantly, and that injunction continued until 2019, when the Supreme Court actually declared that the entire suit premises would belong to Ram Lala Virajman. Now, what were the contentions raised by the parties in these proceedings? Now, kindly see, the date is 21st February 1950. These were the pleadings taken in on 21st February 1950, much before the political parties in question probably came into existence also. So therefore, we need to bear in mind that this litigation traces back to few centuries and documented history, in fact, in courts of law as well, as early as 1885. So in the course of the presentation, I'll take you through all that as well. This is a written statement filed by the local Muslims. The property in respect of which the case has been instituted is not Janmabhoomi but a mosque constructed by Emperor Babur. The mosque was built in 1528 on the instructions of Emperor Babur by Mir Baki, who was the commander of Babur's forces, following the conquest of the subcontinent by the Mughal emperor. So this is what they said in February 1950. The mosque, they claimed, was dedicated as a Waqf for Muslims who have a right to worship there. Emperor Babur laid out annual grants for maintenance. So therefore, their case as filed in this written statement. So in a normal civil proceedings, the person who seeks a relief from the court files a plaint, and the response filed by the other side is referred to as a written statement. They refer to a suit. Now you see, the February 1950, the defense taken by the local Muslims. The suit of 1885 was a suit for declaration. They are referring to an earlier suit that I had mentioned. Declaration of ownership by Mahant Raghubar Das only in respect of the Ram Chabutra, and hence the claim the entire building represented Janmasthan was baseless. As a consequence of dismissal of the suit in 1885, the case respecting Chabutra was not entertained. The Chief Commissioner Waqf appointed under the Muslim Waqf Act has held the mosque to be a Sunni Waqf. So therefore, they acknowledge that there was some proceedings before the courts in 1885 initiated by Mahant Raghubar Das, and those proceedings have culminated in an order rejecting the prayer. So this we will come back to see eventually as the case proceeded, what were the contours of that case and how the Supreme Court had eventually dealt with those things. The further assertions there, Muslims have always been in possession of the mosque. This position began in 1528 and continued thereafter, and consequently Muslims are in a possession of that property by way of an adverse position. Namaz had been offered at Babri Masjid until 16 December 1949, at which point there were no idols under the central dome. If any person had placed any idol inside the mosque with a malified intent, the degradation of the mosque is evident and the accused persons are liable to be prosecuted. On the right side bottom, you would see this is the reference to the para and page from where I am referring to. This is the Supreme Court judgment itself. For convenience, I have referred most of my presentation from the Supreme Court judgment itself, and we've, to the extent possible, have made it verbatim, so that there is no creative liberties which normally our Marxist mythologists do take insofar as our history is concerned. Any attempt of the plaintiff or any other person to enter the mosque to offer worship or for darshan would vitiate the law. Proceedings under section 145 CRPC had been initiated, and the present suit claiming Babri Masjid as place of Janmasthan is without basis, as there exists for quite long another temple with idols of Lord Ram and others, which is actual place of Janmasthan of Lord Ram. So what we get from their pleadings, they say that they've been continuously worshipping in a place built by Babur from 1528, that they were in possession of the property, that there is nothing called Janmasthan there were no deities there was no worship there, and in any case 1885 a suit was filed that was rejected, and therefore you can't claim again afresh at this stage. And in any event, there is another temple in Ayodhya. Later we come to see that it is on the northern side of the present suit property, which is the Janmasthan temple, and therefore this is only a fiction of imagination that people are claiming this. So that's the broad contours of their case. Now similarly, the state of Uttar Pradesh filed a written statement on 25th April 1950. So this is the UP government of that time. The property in suit is known as Babri Masjid and has been used as a mosque for the purpose of worship by Muslims for a long period and has not been used as a temple of Lord Ram. On night of 22nd December 49, the idols of Lord Ram were surreptitiously placed in the mosque, imperiling public peace and tranquility. On 23rd December 1949, the city magistrate passed an order under section 144 of CRPC 1898, which was followed by an order of the same date passed by the additional city magistrate under section 145 CRPC. The dispute property was under court administered receiver ever since. The city magistrate appointed Sri Priyadatta Ram, chairman, municipal board, Faizabad cum Ayodhya as receiver of the property. Similar written statements were filed by other officials of the state at that point of time. Then the Sunni Waqf board has filed a written statement much later. The building in dispute is not Janmasthan of Lord Ram and no idols were ever installed in it. The property in the suit was a mosque known as Babri Mosque, and on the night of 23rd December, the idols was brought in. So this is a consistent plea that all of them have been taken repeatedly. The Muslims alone had remained in possession. So mark the words. Alone had remained in the possession of the mosque from 1528 up to the date of attachment of the mosque on 29 December 1949. So what it means is that they're asserting exclusive possession because they've also taken a legal plea of adverse possession. A plea of adverse possession would mean that a person who does not have title would take possession of a property to the knowledge of the real owner and assert rights over it, and the real owner concedes and not challenge the rights. So after passage of period of limitation as provided under the Limitation Act, the title is lost with the original owner, or the remedy to approach a court for recovery of possession is lost actually. So insofar as private lands, it's usually 12 years, and insofar as government lands, it's 30 years. So therefore, title can be acquired through a legitimate means by acquisition, inheritance, or in any manner approved by the Transfer of Property Act. Alternatively, it is also through adverse possession. So they had twofold argument about their possession. They further claimed that they had offered prayers continuously, and they already existed Ram Janmasthan Mandir, a short distance away from Babri Masjid. So therefore, consistently all the parties have been holding a stand that there is an alternate temple called the Janmasthan temple in Ayodhya. Now this is the Sunni Waqf board. The mosque had the character of a Waqf and its ownership vested in God. The plaintiff was stopped from claiming the mosque as Janmasthan of Lord Ram as a claim in the suit of 1885 instituted by Mahant Raghuvar Das had been confined only to Ram Chabutra, measuring 17 by 21 feet outside the mosque. And then in this replication is the response by the plaintiff in that case. Then it's interesting to note that certain affidavits were filed in the 145 CRPC proceeding. When there's an law and order situation, the city administration can impose certain orders of restraint on members of the community who are actually in conflict of possession or things like that. And then in that proceeding, certain affidavits were given. So this was presented by Mr. Ranjit Kumar. So therefore, as I said, this is an excerpt from the Supreme Court judgment. So you would find the references to counsels' names, etc. also repeatedly, because this is an excerpt from the Supreme Court judgment. Mr. Ranjit Kumar, who had appeared as one of the counsels for Ram Lala, appearing on behalf of the plaintiff in suit 1, adverted to the order of the magistrate under 145 CRPC, where they disputed the premises were attached and a receiver was appointed. Learned counsel stated that 14 affidavits were filed by certain Muslims under Order 19, Rule 1 of CPC between 8th to 16th February 1950. The statement was, the place where the Babri Masjid was situated is the birthplace of Lord Ram. The Babri Masjid was built by breaking the birthplace of Lord Ram. After British rule, Muslims were only reading Friday namaz in the mosque. After the construction of the masjid, Hindus did not give up their position and continued to worship there. So, you will mark the date. This is 8th to 16th of February 1950 by the residents of Ayodhya. So, there was no proceedings other than the 145 CRPC proceedings which were happening at that point of time, and the local Muslims had given these affidavits. Multiple affidavits were given to this effect. Both Hindus and Muslims continued to worship at the disputed site. Post the riots of 1934, Muslims had stopped going to the masjid out of fear, and ever since, the Hindus had taken possession of the main place in the mosque. There was no objection if the position of the mosque was to be handed over to the Hindus, as reading namaz at that place was against Sharia. So this was the affidavits. Justice Sudhir Agarwal, which is the Allahabad High Court's lead judgment, there were 3 judges, full bench, which had conducted the trial in the Allahabad High Court. Justice Sudhir Agarwal's judgment is the lead judgment. Justice D.V. Sharma and Justice Ashok Khan were the other 2 judges. So there was an overlap of findings, and the lead judgment happens to be of Justice Agarwal. The aforesaid documents, to the extent to prove the fact that the same were filed before the magistrate and constitute part of the record of 145 CRPC proceedings before the city magistrate, is not disputed, but to believe the contents thereof, in our view, it was necessary to produce the authors of the documents and to give an opportunity of cross-examination to the other parties against whose interests the documents contain certain averments. None of the authors of the said documents have been produced, and they are also not party to the proceedings individually. We have no benefit of testifying the correctness. So what happens here is, though the affidavits which were filed were part of the plaint proceedings in the suit proceedings in the present civil case, the High Court and also the Supreme Court were of the view that since the authors of those affidavits were not available for cross-examination, much weightage cannot be given to that. But the fact remains that people had given affidavits, though the court may not give due weightage to it. But that's part of the proceedings what transpired. That's the reason I had to place this. None of the persons who are alleged to have filed affidavits in the proceedings of 145 in examined cross. So none of them were obviously not available when the trial commenced in the Allahabad High Court in the 90s. So they were not available to be cross-examined. So therefore, their affidavits alone, in the absence of they being available for cross, could not carry much weight in the eyes of law, is how it has been dealt with by the Supreme Court also. Now, this is a suit filed by Nirmohi Akhada. If you note the date, 17 December 1959. So this is effectively the second suit which has been filed, though there was one other suit, but I would not go into those nitty-gritties because there's not much of consequence on the final outcome. The suit was instituted on 17 December by Nirmohi Akhada through Mahant Jagatdas, seeking a decree for the removal of the receiver from the management and charge of the Janmabhoomi temple and for delivering it to the plaintiff. The cause of action is stated to have arisen on 5th January 1950 when the management and charge of Janmabhoomi temple was taken away by the city magistrate and entrusted to the receiver. So basically, Nirmohi Akhada's case was that they are the Shabayats of the Ram Janmabhoomi temple. The worship was being under their management. That's the sum and substance of their case. So they played that there exists in Ayodhya since the days of Yod, that is effectively times immemorial, an ancient mutt or akhara of Ramanandi Bhairagis called the Nirmohis. This is a religious establishment of a public character. The Janmasthan, commonly known as Janmabhoomi, is the birthplace of Lord Ram and belongs to and has always been managed by Nirmohi Akhada. Nirmohi Akhada is a Panchayati mutt of the Ramanand sect of Bhairagis, which is a religious denomination. The customs of Nirmohi Akhada have been reduced to writing by registered deed dated 19th March 1949. Nirmohi Akhada owns and manages several temples. No Mohammedan has been allowed to enter the temple building since 1934, and acting under the provisions of section 145 CRPC, the city magistrate placed the main temple and all other articles in it under 35 charges of the first defendant as receiver on 5th January. As a consequence, the plaintiffs have been wrongfully deprived of the management and charge of the temple. So they claim that they were in management of that place and they've been wrongfully removed and a receiver has been appointed. So they may be restored to the management. That's the substance of their claim. So this has been again opposed by the residents of Ayodhya and others. The reason I've captured this is to show that there have been extensive pleadings on these issues and stand being taken by parties as early as 1950 onwards. Now, this is the suit filed by the Sunni Waqf Board, the OS 4 of 89. It was originally filed as suit number 12 of 1961. The suit 4 was instituted on 18 December 1961. As I mentioned, though a suit for injunction was filed on 16 January 1950 seeking continuation of prayer, etc., no such prayer was ever made by residents of Ayodhya by filing any case. So this may be an important aspect as to the interests of the local Muslims qua the others, because this case has been driven by most often than not by people outside Ayodhya. It has been averred that the suit has been instituted on behalf of the entire Muslim community together with an application under Order 1 Rule 8. The Civil Procedure Code permits that in matters where there is a large common interest of more people, the larger segment of people, an application under Order 1 Rule 8 of CPC is filed so that it is contested in a representative capacity for the whole community. So the Sunni Waqf Board filed this application and sought to represent the entire Muslim community against the entire Hindu community on this claim. A declaration was sought to the effect that the property indicated by the sketch to the plaintiff is a public mosque commonly known as Babri Masjid, and that the land adjoining the mosque shown in the sketch mapped by letter so and so is a Muslim graveyard as specified in so and so. So that was their prayer. That in case of the opinion of the court, delivery of possession is deemed to be the proper remedy. A decree of delivery of possession of the mosque and graveyard by removal of the idols and other articles which the Hindus may have placed in the mosque as objects of the worship be passed in plaintiff's favor. That the statutory receiver be commanded to hand over the property in dispute described in Schedule A of the plaint by removing the unauthorized structures. Now, the averments in the Sunni Waqf fort plains are important. So what is the edifice, the foundation of their claim? The foundation of their claim is that Emperor Babur had come 433 years ago, conquered India and occupied the territories including the town of Ayodhya and he has built a place of worship and performance of religious ceremonies. They also refer to the 1885 suit of Mahant Raghuvar Das that he had earlier filed and lost, and therefore the Hindus have no claim qua this land. Now the important part is the Masjid is supposed to have been constructed on a vacant land. So that's the foundation of their case, that it has been built on a vacant land and there existed no other structure on which Babur had constructed the temple. According to the plaintiff, assuming without admitting that there existed a Hindu temple as alleged by the defendants on the site of which mosque was built ago by virtue of their long, exclusive and continuous possession commencing from the construction of the mosque and ensuing until its desecration perfected their title by adverse possession. So therefore, as I said, on one hand they are saying they built it on a vacant land. On the other hand, they say that in any case, once the masjid has been built and it has been in the possession of the Muslims for 433 years, so by adverse possession they have perfected their title and therefore they have to be given the property. The relief which have been claimed in the suit are based on the above averments. Essentially, the case of the plaintiff proceeds on the plea that the mosque was constructed by Babur 433 years prior to the suit as a place of public worship and has been continuously used by Muslims for offering prayers. Even assuming that there was an underlying temple which was demolished to give way for construction of the mosque, the Muslims have perfected their title by adverse possession. On this foundation, the plaintiffs claim a declaration of title, and the event that such a prayer is required, a decree for possession may be granted. So this suit again has been opposed by the Hindu parties who had filed their suit, and then several others have filed, including the Nirmohi Akhada. So basically, the suits were contested extenso by both sides. Now we come to the suit number 5 of 1809. This is when Ram Lala enters court. Ramo Vigravahan Dharmaha is how we identify Rama. He's always followed Dharma, and by the time he chose to come to court, constitution was in place, and the constitution provided for the methods of contesting any claims of title, ownership or property. So as a dharma abiding ruler in his times and as a idol of dharma, he files a suit to a next friend. So now what this concept of filing of a suit by a deity is a very core idea of Sanatan Dharma. Because when we have a temple worship or an idol worship, what we are actually worshipping is a living God which has been invoked into an idol through the traditional shastras which are applied while building the temple in question. So even when we do a Satyanarayana Katha at home, there are mantras which are recited whereby we invite the various deities and then we also actually bid them adieu. So we do that for Ganesh Puja, we do it for Durga Puja. So that is the tradition. So that is recognized by law. The English courts also have always recognized this principle of a living entity as a worshipped deity in our temples. So that concept is what has been brought into courts where an interest of a living deity, see, because there have been a lot of endowments which would be made in the name of temples, in the name of the deities. So they have to be managed by their managers or shabayats, etc. But there also are worshippers and devotees who are interested in the well-being of the deity so that the dhoop, deep, naivedya, vagara are properly taken care of because it's a living entity for us. It's a part of a family for people who have such living deities as part of their own residence. So in that spirit, when it is not being properly taken care of, any deity can approach the court as a next friend and take the court's permission to represent the deity. So in this case, Ram Lala Virajman came to court through a next friend, Mr. Devaki Nandan Agarwal, or a former judge of the Allahabad High Court, a law-knowing person, to represent his own cause. The suit was instituted on 1st July 1989, claiming the following reliefs. A declaration that the entire premises of Sri Ram Janmabhoomi at Ayodhya as delineated so-and-so belongs to the deity. That is, he is asserting his ownership in his own self, that the temple belongs to me, The land belongs to me and I am the owner. So that is the declaration he is seeking in court of law. A perpetual injunction against the defendants prohibiting them from interfering with or raising any objection to or placing any obstruction on the construction of the new temple, including at Sri Ram Janmabhoomi Ayodhya, after demolishing and removing the existing buildings and structures, etc., situate thereat, insofar as it may be necessary or expedient to do so. So, if you contrast the prayers, the prayer in the Waqf board was to removal of idols, and the prayer in Ram Lala is to remove the structure and the Bhavi temple to be built. So, they were very clear that it is an exclusive position of each as against a shared position which was being contested and had led to a lot of bloodshed. The suit has been instituted in the name of Ram Lala Virajman at Ram Janmabhoomi, also called Bhagwan Sri Ram Lala Virajman. The deity source is described as the first plaintiff. The second plaintiff is described as Asthan Sri Ram Janmabhoomi Ayodhya. So, therefore, the place itself was sought to be asserted as a juristic person. Now, Asthan as a juristic person is a new concept which was put forward before the court. In the case on hand, the plaintiff number 1 was accepted. The plaintiff number 2's case, as a juristic person, the court had its reservations. So, as the relief was being granted to Ram Lala Virajman himself, the finding on the second plaintiff is of not much consequence. Now, if you understand the concept of Asthan as a deity, we are people who worship Bhumata. So, therefore, there are people who worship Mother Earth before they actually put their feet first thing in the morning. So, this is the essence of our Sanatan practice, where we accept nature as mother and we worship the nature. So, in that sense, there are places which are actually of great significance. So, we are calling certain places as Dham, as a Punya Kshetra. So, Kashi, Mathura, Maya, Ujjain, these are all places which are very important pilgrimage wise and otherwise also, because they grant people who visit moksha. That's the faith of our people. In fact, if I might just digress, the Kamba Ramayana speaks about Sugriva giving directions to his forces to go in search of Mata Sita. So, the instructions are given to Hanumanji, saying that you go in a particular direction, you will find Venkatadri, which is popularly known as the temple of Balaji in Tirupati. It's referred to in Kamba Ramayana. I got to know it thanks to Parasaranji. So, there he says, please don't put foot on that holy hill, because once you put your foot on that holy hill, you will get moksha. So, you will not be able to pursue your task of searching for Mata Sita. So, from distance, worship that place and then move on. So, therefore, for us, Kshetra has this importance and significance. So, Ayodhya is one such Kshetra, and the place of birth becomes even more significant for us. In the evidence, I will show why that place of Janmasthan is also very significant for us. The identification of Ram Janmabhoomi for the purpose of plaint is based on the site plans and the building premises and registration area prepared by Sri Shivrang Shankar Lal, who was appointed as commissioner by the civil judge at Faizabad in suit number 1 of 1950. So, therefore, once the suit was filed, a commissioner was appointed to actually take photographs, etc., as to what is there in that structure, and the suit property has been actually identified, so that there is no dispute as to the location and the extent of the suit property. The plaint contains reference to the earlier suits instituted before the civil court, and the religious ceremonies for attending to the deities have been looked after by the receiver and appointment in proceedings under section 145. Although seva and puja of the deity have been conducted, darshan for the devotees is allowed only from behind a barrier. So, that was the restricted darshan that was being given. So, this is broadly the map that we are referring to. If you see the map on the left side, you find a rectangular structure with again a partition in the middle of the rectangle. So, the portion inside that is referred to as the inner courtyard, and the portion which is in a U shape outside that is referred to as the outer courtyard. So, the entire space, if you look at it, is about 1470 square yards, which is the suit schedule property in this title dispute. 1470 square yards is the suit property. Thereafter, acquisitions happened by the state and the central government, so the land in question increased. The suit of Nirmohi claims to be the manager as a Shabayat. So therefore, Ram Lala suit says that the management of the place has not been properly done and there's been mismanagement. So averments were made. Otherwise, in the presence of a manager, where is the question of deity to come forward to present their case directly is the issue which would crop up. So there is a specific averment of mismanagement also, which is made. And then they plead extensively. The place itself, Ram Janmasthan, is an object of worship since it personifies the divine spirit worshipped in the form of Lord Ram. For us, certain places gain great significance. In Delhi itself, when I came as a tourist in 1980s, the late 80s, the tourist tour invariably had a few places, including the place where Gandhiji was shot, Indira Gandhi was shot, etc. So therefore, those places have significance in contemporary history also. Therefore, a birthplace of Radlam definitely had a significance for centuries in this land. The actual and continuous performance of puja of an immovable deity by its devotees is not essential for its existence. So the question was whether there was a worship happening or there's a break of worship also. So what happens in case there's a break in worship? So on that issue also, a lot of debate happened. There were references to the Bumpers case where a Nataraja idol was stolen from Tamil Nadu. A broken temple could also sue recovery and then said that a temple, though broken, is actually recognized to be a juristic person to assert its right to recover the idols which have been stolen, is recognized by the English courts and the Canadian courts also. So those judgments were cited in support of this assertion that though there may be a temple which was broken, it still continues to be a temple and it has its rights which can be asserted in a court of law. So the history of the documented history through the gazettes, etc., are also pleaded in this suit. And then the place belongs to the deities and no valid Waqf was ever created or could have been created. So here we need to understand there is two different faiths where two different systems of their own theological identity of properties and concepts are at contest in a court of law. Under the Waqf, Islamic concept of endowment, the requirements are that the land should be owned by the person who is a Waqif. So therefore, it could not have been on a land which is encroached or taken by force. That's haram. That's not permissible. So there was a lot of arguments on those lines also which were made. But eventually the court chose not to get into those theological questions because all said and done, the court said it is a civil dispute on title and so we'll confine ourselves to those issues because if you're actually trying to contest and then decide as a secular court which theology will be given precedence over the other would be a difficult question for a civil court to answer. So therefore, the courts chose that the questions of theology will not be gone into. So it is a case where once a masjid, always a masjid was pleaded in the arguments and the response to that was once a temple, always a temple. So that actually crystallizes the real core of the issue between the two parties who've been contesting. The structure which was raised upon the destruction of the ancient temple, utilizing the material of the temple does not constitute a mosque. So therefore, theologically also, Islam as a faith believes in formless worship. So therefore, presence of any idols of any human forms, much less a woman or a female forms or animal forms is completely prohibited in their place of worship. So the existence of pillars with these carvings inside the place they assert to be a mosque was also questioned on their own theological basis that whether it can be a place of worship under Islam in the presence of those many idols inside the central dome itself. So that was also pleaded as a case to support the contest that it was never a mosque. It was only destroyed from being worshipped as a temple and it was never converted to be a mosque either in fact or in theology could it have been a mosque was the contention taken in these pleadings. And of course, whether prayers have been happening in after 1934 or not is a contested fact. The courts finally come to a conclusion that the prayers were happening on Fridays post 1934. That's a finding which comes, we'll go to it a little later. It says that the Ram Janmabhoomi at Ayodhya, which contains besides the presiding deity, other idols and deities along with appurtenating properties constitute the integral complex with single identity. The reason that we are asserting on the single ITT or a composite unit is because the map that I showed had an inner and outer courtyard, and how it has come about I'll also deal with once I reach the evidence part. And as all we know, on 6 December 92, the structure was brought down, and that led to some other proceedings as well. Now, Nirmohi Akhada questioned the claims of Ram Lala Virajman. So it became a very interesting case where the Shabayat is questioning the deity. So that's became a bone of contention within the Hindu community. So this was a pleading that they have asserted that the Ram Lala could not have been represented through a next friend because the Shabayat is very much there before the court. So that was the substance of their challenge, and Sunni Waqf Board again reiterate their case, which they have pleaded in their own OS 4, and then they oppose the plea of Ram Lala, and they also make assertions that this is a politically motivated litigation, etc. The Muslim residents also were made parties, and they also filed their own written statements. And then Prince Anjum Khadir, I think he represented the Shia Waqf Board also. The Shia conference also filed a petition. In fact, there was a dispute within the communities, Shias and Sunnis, and that also landed in court because the interesting fact is Babur was a Sunni, and his army chief, Mir Baqi, who was supposed to have built this place, is a Shia. So whether it's a Shia Waqf or a Sunni Waqf was also a dispute between the communities, but eventually it appears that they've settled down. The Sunni Waqf Board succeeded in their inter-se litigation in 1946. So broadly, the issues which have been crystallized on these pleadings are this. The procedural notice on section 80, religious denomination, res judicata. Res judicata is that once it is already decided by earlier proceedings between the same parties, you can't bring the same case back to the court. So the reference to Mahant Raghuvar Das case of 1885 is a concept of law, where you can't go back to the court with the same litigation between the same parties once it has been decided between them. So then Waqf Act implications of the notification, miscellaneous issues of representative nature, deities, their status, rights, limitation, possession, adverse possession, site as birthplace, existence of temple and demolition if any, character of mosque, identity of property, bar of specific relief. So these are all possible issues were made. Now I come to the part 2 of this. There are procedural orders which have been filed. During the course of the hearing, the trial court recorded the statements of the parties and their pleaders under the provisions of Order 10, Rule 2 CPC. Mark the date 8th August 1962. It was stated on behalf of the Sunni Central Waqf Board that the property in suit is a property dedicated to Almighty God and is a mosque for the use of the entire Muslim community at large. 28th August 1963, it was stated by the Waqf Board that in the alternative, if the defendants had any rights in the property, it stood extinguished by a lapse of time and the plaintiff had acquired title by adverse possession. 11 January 96, the statement of Mr. Jafrayab Jilani, he was the chairman, I think, of the Babri Masjid Action Committee and also a senior advocate, a very erudite lawyer. Learned Senior Counsel appearing for Sunni Waqf Board recorded to the effect that the mosque was situated in Nozzle plot, Nozzle is a government land, of Khasra so-and-so, Mohalla Kot Ramchandra, known as Ramkot Ayodhya. The irony of their case is that their mosque is in an address which is called Ramkot. 22nd April 2009, following statement of Jilani, Mr. Jilani, Learned Senior Counsel was recorded. For the purpose of this case, there is no dispute about the faith of Hindu devotees of Lord Ram regarding the birth of Lord Ram at Ayodhya as described in Valmiki Ramayana or as existing today. It is however disputed and denied that the site of Babri Masjid was the place of birth of Lord Rama. It is also denied that there was any Ram Janmabhoomi temple at the site of Babri Masjid at any time whatsoever. So what the significance of this procedural order is, in a trial, a person who goes to court, the burden is on him to prove every fact that he asserts in his plaint. Now, to assert that Ram is a Ram referred to in Valmiki Ramayana, son of Dasharatha, born in Ayodhya, would have to be proved first by the Hindu parties, including Ram Lala himself. But that would have taken a lot more time to lead evidence. So probably to cut short this litigation, to reduce the scope of the litigation, this statement has been recorded that they are not disputing that Ram, son of Dasharatha, was born in Ayodhya, and the present Ayodhya is Ayodhya referred in Valmiki Ramayana. So therefore, there is no need to prove it independently in view of the statement made under CPC. So once parties make a statement, that statement will reduce the scope of dispute when both parties are agreeing on certain facts. So that is the purpose of this statement. The existence of Nirmohi Akhada from the second half of 19th century onwards is also not disputed. It is, however, denied and disputed that Nirmohi Akhada was in existence, especially in Ayodhya, in 16th century AD or in 1520 AD, and it is also denied that any idols were there in the building of the Masjid up to 22nd December 49. So therefore, they have tried to reduce the area of dispute by giving this statement. Similar statements were made on behalf of other councils representing the Muslim parties. So therefore, it is not one straight statement, but multiple councils have made similar statements, probably as a matter of common strategy to expedite the trial in the matter that the scope of the proceedings will be reduced instead of having to do a wider evidence on those issues as well. On 10th July 1989, all suits were transferred to the High Court of Judicature at Allahabad. On 21st July 89, a three-judge bench was constituted by the Chief Justice of the High Court for the trial of the suits. On an appreciation by the state of Uttar Pradesh, the High Court passed an interim order on 14th August 1989, directing the parties to maintain status quo with respect to property in dispute. On 30th September 2010, the full bench of the High Court, comprising of so-and-so, had delivered the judgment. Now, so with this, the Allahabad High Court judgment came into place. There were attempts to delay the pronouncement of the judgment of the Allahabad High Court as well. On 30th September 2010, I remember as a matter of my memory in the court, a petition was filed sometime after 20th September, stating that one of the judge was about to retire and the judgment may not be pronounced. That pronouncement of judgment could lead to a lot of law and order problems. So therefore, an attempt to reconcile the matter through some kind of a community effort should be taken and the judgment should not be delivered. So that petition came to be filed in Supreme Court. A bench of Justice Ravindran and Justice Gokhale, as I recall, had difference of opinion whether to entertain that petition to defer the pronouncement of a judgment after such a lengthy trial or not, and the matter landed eventually before the then Chief Justice of India's court, who dismissed the petition and which paved the path for the full court to pronounce the judgment. The judgment came with a tripartite partition. So what happened is, the central dome was given to the Ram Lala Virajman, the suit of 5. Certain portion in the outer courtyard was given to Nirmohi Akhada, and certain other portions were given to the Waqf board, which was never the prayer of any of the parties. So in effect, this is usually done in a partition suit within families. But this was done without any prayer to that effect. So normally in a civil court, the pleadings are and the prayers are what the court is circumscribed by to grant relief. The normal civil courts, the constitutional courts have higher powers. So they could not have traversed beyond the prayers and granted such relief is the primary ground of challenge by all the parties in the trial. So therefore, there were multiple appeals which were filed by all concerned. On 9th May 2011, a two-judge bench of the Supreme Court admitted several appeals. You see the language of this court is because it's an excerpt from the Supreme Court. Admitted several appeals and stayed the operation of the judgment and decree of the Allahabad High Court during the pendency of the appeals. Parties were directed to maintain status quo with respect to the disputed premises in accordance with the directions issued in Ismail Farooqi. That is another constitution bench judgment. I'll refer to that in a moment. The registry of this court was directed to provide parties electronic copies. On 10th September 2013, 24th February, so on, so and so, directions were issued for digital records of evidence, etc., etc., and then the matter was proceeded gradually. On 10th August 2015, a three-judge bench of the court allowed the Commissioner Faizabad Division to replace the old and worn-out tarpaulin sheets or the makeshift structure under which the idols were placed with new sheets of the same size and quality. Here, from 1949, 23rd December, the idols were there in the structure. 6th December 92, the structure was pulled down and then there was a temporary tarpaulin sheet structure, which was a temporary temple was built and which the idols were kept. So to move or replace those tarpaulins which getting torn by wear and tear of weather were also strictly controlled by proceedings before courts. So the usual tariq pe tariq used to happen whenever there was a need to change the tarpaulins also. This is one such instance in 2015. On 10 January 2019, the registry was directed to inspect the records required, engage official translators. On 26 February, this court referred the parties to a court-monitored mediation to explore the possibility of bringing about a permanent solution. So, a three-member committee of mediation panel with Justice Khalifullah, a former judge of the Supreme Court, Sri Ravi Shankar, and Sri Ram Panchuji, a very renowned mediator, was formed by the Supreme Court. Sri Ravi Shankar had been actually in his own individual endeavors working on this effort of trying to reconcile the parties to come to a amicable solution for going forward with resolving the most difficult problem which has been plaguing the nation for centuries. But unfortunately, that did not materialize, and then another attempt was made while the matters were pending in the Supreme Court. On 8th March 19, the comprising of so-and-so was constituted and time granted to mediators to complete the mediation proceedings by 10th May 19. And the settlement did not happen, and then the matter was mentioned. The hearing was directed to be commenced from 6th August 2019. So, as we see, the hearings commenced. The attempt for mediation continued for some time, but unfortunately, there was no consensus amongst the main contesting parties. There were several other parties who were also before the court, who were actually giving indications that they are willing to settle. But the main parties, namely the Sunni Waqf Board or Ram Lala Virajman, to my understanding, none of them were in agreement of any mediation. So, there was a lot of others who were trying to make an effort in a very good faith, I believe, and unfortunately that didn't materialize, and the matter had to proceed for hearing. Then we move to the documentary evidence. So broadly, the evidence, as I see, if you see the plain suit number 1 was the original suit of 1950, filed on 16 January 1950. The suit 4 is the suit by Suit 3 is Nirmohi Akhada, Suit 4 is Sunni Waqf Board, Suit 5 is Ram Lala Virajman, and then Suit 1 is the original 1950 suit. So, there are about documents filed in each of the suits, and then exhibits marked, total 533 exhibits in multiple languages, and they broadly comprised of religious texts, travelogues, gazetteers, translations of inscriptions on pillars, reports of archaeological excavation, photographs prior to demolition, and details of artifacts found at the disputed site. I would refer to few of them. I mean, my non-reference does not mean they don't exist. It's just that it's too bulky. So, now we are referring to the Valmiki Ramayana itself, which was filed in the court. So, there a reference to the Ayodhya as a city. So, here Vishnu was approached because of the atrocities being committed by Ravana, and then he assures that I will take birth as son of Dasharatha. So, he chooses his father, he chooses his place of birth, Ayodhya. So, therefore, it becomes great importance for us. So, because Vishnu himself has chosen the place of birth. I mean, as a matter of fact, that you can change your name, probably you can change your gender, but you cannot change your place of birth even on your passport. So, therefore, the question of change of place of birth of Ram was the problem that we had confronted with, and could not accept any other place of birth which was suggested by the Muslim parties, and that there was a place called Janmasthan Mandir on the north of the premises. As we see the case proceeds, it kept coming closer to where we always believed and worshipped. Setting course through the history, the cornerstone of edifice of the Hindus is their faith and belief in the birthplace of Lord Ram as incarnation of Vishnu. Their faith is founded principally on the significance attached to the Ayodhya in the following religious scriptures, principally the association of Ayodhya with the presiding deity of Lord Ram in Valmiki's Ramayana, Skanda Puran, Sri Ramcharitmanis, etc. So, therefore, a lot of traveler gazetteers, etc. are there. In weaving through the wealth of documents produced before this court, it is necessary to answer both the extent of judicial review of faith and belief and evidentiary value of reliance on travelogues. The first extract of Skanda Purana upon which reliance has been placed is so and so. So, therefore, there was an attempt to actually locate the exact Janmasthan from various ancient texts, Skanda Puran, etc., by reference to Sarayu Nadi and the topographical descriptions. Like if you have read Ramayana or Mahabharata, there are geographical locations of triangulation to identify a place which are given and then which are broadly referable even now. If you drive to Kedarnath or Badrinath, you will find references to the Shanti Parva references in the Mahabharata of the travel of the Pandavas when they were about to leave their bodies. So that's the history of this land. So we call them as Itihas, though the Marxists in their mythology refer to as imaginary. The Skand Puran contains an edict of the devotees to offer worship to Lord Ram as means of salvation. There is a reference to the place of birth of Lord Ram in another extract. So therefore, multiple extracts of religious texts from Skanda Puran, etc. have been placed and they are quoted by the Supreme Court as well. So if you see the right side bottom, you get the reference to the quote from the Supreme Court judgment. Travelers and gazettes and books. So William Foster, Exhibit 19, Early Travels in India, 1583 to 1690, which contains narratives of 7 Englishmen who travelled in modern and western India during the reign of Akbar and Jahangir. These travellers are Ralph Fitch, William Hawkins, William Finch, Nicholas Whittington, Thomas Coryat, Edward Terry. Among them, William Finch arrived in India on August 1608 at Surat with Captain Hawkins. According to the Hindu party, the significance of the account of William Finch, who visited Ayodhya between 1608 and 1611, is that he did not find any building of importance of Islamic religion. So the claim of 1528 built of Masjid, there is no reference in the contemporaneous traveller records. There is a reference in the travel of William Finch to Ayodhya. The Audh from there is 50C, a city of ancient note and seat of Khotan king, now much ruined, the castle built for 100 years ago. Here are also the ruins of Rani Chand, castle and houses, which the Indians acknowledge for the great god, saying that he took flesh upon him to see the tamasha of the world. In these ruins, Ramayana certain Brahmins who record the names of all such Indians as washed themselves in the river running thereby, which customs they say hath continued 4 lakhs of years, which is 394,500 years before the world's creation. The Excavation rules of Ranikchand castle and houses has appended to it a footnote stating Ramchandra, hero of Ramayana. The reference is to the mount known as Ramkot or Fort Ram. Exhibit 133, Suit Fire. Joseph Stiefenthaler wrote his travel account in Latin in his book titled Description of Historicate. Stiefenthaler was a Jesuit missionary, reportedly a proficient in Arabic, Persian and Sanskrit, and visited India in 1740. His travels were between 1743 to 1785. His visit to Ayodhya is described in the text, which was made available during the course of the trial in French. An English translation was furnished by the Government of India in pursuance of an order of the High Court. Stiefenthaler's account reads thus. Avoid called Ayodhya by the educated Hindus is a city of very olden times. Its houses are mostly made up of mud only, covered with straw or tiles. Many are made of bricks. The main street goes from south to north and it has a length about a mile. The width is little lesser. So it's a very descriptive things. I'll skip through. Close to Sarogdari is a building constructed lengthwise by Navarya Hindu, a formerly lieutenant. So Sita Rasoi, these are all places which are referred to by those Jesuit as well. And then 12 of these 3 pillars now support the interior arcades of the mosque. So therefore the structure with the pillars have been recorded by historical travelers also. So we have these travelers. Then Robert Monbury Martin wrote the history of antiquities, topography and statistics of Eastern India. So I'll skip this. Edward Thornton, again this documents of 1858. So therefore from 1608 onwards, there's continuous record of history by various travelers. Alexander Cunningham, 4 reports made during 1862, 63, 64, 65 also had references to the worship of Hindus at Ram Janmabhoomi or the Janmasthan Mandir. And then you have P. Carnegie, the officiating commissioner and settlement officer, Faizabad, historical sketch of Faizabad. He also referred to this. Interestingly, Ayodhya, which is to Hindu what Makkah is to the Mohammedan, Jerusalem to the Jews, has in the tradition of the Orthodox a highly mythical origin, being founded for additional security not on earth, for that is transitory, but on the chariot wheel of great Creator himself, which will endure forever. The various Hindu parties placed rely on account of Carnegie. So therefore, these are the recognition of faith being practiced there. Carnegie's account, which was published in 1870, was added to the incident which took place in 1855, involving a conflict between Hindus and Muslims. Now we are talking about a year or two before the First War of Independence, 1857. He refers to worship being offered by both Hindus and Muslims in the mosque temple prior to the incident and to the construction of a railing thereafter. With a view to prevent disputes, Carnegie notes that the railing was put up so as to separate two communities by allowing the Muslims to worship within its precincts in the mosque, while the Hindus had outside it raised a platform to make their offerings. So the partition of inner and outer courtyard of a contiguous building happened during the British time in around 1856 and 1857. The Hindus' access to the inner courtyard, where the central dome, where the Janmasthan was there, was restricted. They were worshipping from outside the railing wall which was built. The Gazetteer of Ayodhya 1877, A. F. Miller 1880, H.R. Neville 1902. So these are the documents which were there. Exhibit 10, the Imperial Gazetteer, Hans Baker wrote Ayodhya in 3 parts. So there are multiple travelers' notes. So now we move to the oral evidence. So this is the documentary evidence. This is just a glimpse of a few of the exhibits there. The cross-examination of Hindu witnesses, Mahant Ramchandra Das. Mahant Param Ramchandra Das was 90 years old, and Mahant of All India Sri Panch Ramanandi Digambar and Akhada. His statement is mentioned in Valmiki Ramayana that Lord Ram was born in Ayodhya. Description of Ayodhya has been made in Vedas, Upanishads, in codes, and in 18 Puranas, in Smritis, and in recognized works of Sanskrit literature of Bharat. In all these, Ayodhya has been accepted as the birthplace of Lord Ram. This is the same Ayodhya which exists at present of Lord Ram. So therefore, oral depositions also came. The witness stated that Skand Puran in the chapter relating to importance of Ayodhya contains a reference to the birthplace of Lord Ram. He stated that the Garbhagriha is at the disputed place where the idol of Ram Lala was in existence at the time of his deposition. I don't recall if it is his deposition when he was put to cross-examination. A question was put, where is the labor room in Ramkot? So, and he answered with Garbhagriha. Now we understand what Garbhagriha is. Every temple has a Garbhagriha, and we would not have correlated to a labor room because all of us have come from the mother's womb, and that is the place which we refer to as Garbhagriha. So that's what he says in a cross-examination. The witness stated there were engravings containing depictions of gods and goddesses on the pillars under the dome which were worshipped. He stated that the place below the middle dome, in the place where Lord Ram was born and is represented the Garbhagriha. The witness deposed the importance of Ayodhya and religious texts. Deposing to this behalf, witness stated, in this connection there is a reference in Ramcharitmanas that Uttat Dishibahi Sarayu Pavini. This is an authentic statement about the location of Sarayu river. There is a statement in Ramayana, that is Ramcharitmanas, regarding the importance of Ayodhya, that Avadpuri Mam Puri Shuhasini, which makes it clear that Ayodhya is the birthplace of Lord Ram. So therefore, references from all religious texts are there. It has also been mentioned here that people living here are very dear to me. The place where a person is born is called his birthplace. It has also been mentioned in Valmiki Ramayana that the land of my birth is dearer to me than Lanka. Janani Janmabhoomischa Swargadapi Kariyasi. That's what Ram says when he's offered the kingdom of Lanka as well. The faith of Hindus of entire world over towards Ram Janmabhoomi Sthal is similar to that of Muslims towards Kaaba. There is only one Ram Janmabhoomi temple in the whole of the world, whereas there are thousands of temples of Lord Ram. The cross-examination continues. The whole place being the birthplace of Lord Ram is a symbol of belief and faith for me. Cross-examination continues. Mr. Jilani questions, from time I first came to Ayodhya till 34, I had been going to Ram Janmabhoomi regularly every day. At that time, I used to go to that portion of the disputed building where pillars were installed. There were 2 pillars installed at the eastern gate. I used to have darshan of them also. Statues of gods were engraved on those pillars. 2 pillars of black stone were installed inside the main building. Volunteer that the pictures of gods were engraved on stones thereon. There was a statue of Hanumanji on one of the 2 pillars of eastern gate, and the second statue was a broken one, which was also of some god or goddess. There was a wall of iron bars after the main gate, and there was 3 gates thereafter in the main building, and pillars of black stones were installed in all the 3 gates. The witness alluded to the location of the pillars of black kasoti stones and to the depiction of Hindu gods and goddesses on them. What was the location of the pillars of black stones installed inside? There were 4 pillars in every gate. There were statues of gods, goddesses in 4 pillars in the southern gate. Some of them were clear and some were not. I cannot say that the statue of which god or goddesses was engraved on southern gate or any other gate. Before 1934, I used to have darshan of Garbhagriha situated under the middle shikhar. So the central dome is being referred to as middle shikhar. After Ram Chabutra, besides, I used to have darshan of the statues engraved on the pillars and offered tulsi leaves. The witness made a distinction between a Garbhagriha and outer platform. Question: in addition to the disputed buildings and the platform outside, do you consider the land adjacent to it as Garbhagriha by other platform? I mean the platform outside the disputed building. Garbhagriha is the place where Ram Lala is seated Virajman at present. Outer platform is outside the disputed place. So therefore, they were trying to probe if you would agree that the Garbhagriha is outside the central dome or where it was. But he denies that. According to the witness, the Garbhagriha represented the birthplace of Lord Ram, and this was place where on 23rd December 19, the idol was installed after removing it from the Chabutra. Ramnath Mishra alias Panarsi Banda. 6th August, he was examined. When the examination teacher was recorded, he was 91 years old. He stated that he was married to the daughter of so-and-so, who was a reputed Tirth Purohit. He deposed to having worshipped at Ram Janmabhoomi and of performing the parikrama since his marriage. Since 1932, he together with his spouse came to Ayodhya and started managing and looking after the work performed by his father-in-law, including of about 100 ghats which are owned by him. The witness stated that the importance of Ayodhya had been described in the Brahma Puran, Skanda Puran and Brahma Puran. See, we are talking about people who are 90-year-old who come to court to give evidence of their worshipping, their performing parikrama as a primary evidence. So there were people who were living who had been born early 1910 or so, who come to court and say that from 1930s I have been worshipping there. So therefore, there is direct evidence of practice of faith there. Then we come to the archaeological evidence. Before going to the archaeological evidence, I would like to draw your attention to the Constitution Bench judgment, a dissenting opinion in the Constitution Bench judgment. This Ismail Faruqi's case was post the demolition. The entire premises was acquired and all suits were declared to have abated by a central enactment. So all sides challenged them, some before the Allahabad High Court, some before the Supreme Court, and also a presidential reference was made to the Supreme Court under Article 143, seeking its opinion as to whether a pre-existing Hindu temple existed where the demolished mosque was there. So the Supreme Court declined to answer the reference and also struck down the provisions where they declared that suits will abate. The Supreme Court set out the doctrine of separation of powers as a basic feature of our constitution, that any dispute will have to be adjudicated under our constitution only through a judicial adjudication, and the legislature or executive cannot step in and take over the function of the judiciary. It is of great significance because it goes to the core of doctrine of separation of powers under the constitution, by virtue of which the entire judiciary is the sole repository of adjudication of disputes. And through this central enactment, the suits which were pending for almost 50 years or 40 years were sought to be abated. So the court struck down the provision of abatement, read down the provisions, and they said that the court would be permitted, the civil court or the full court, which is citizen of the matter, will continue with the trial, and then the central government would be only acting as a receiver to hand over the premises to the successful party as and when the suits are adjudicated. The scope of this proceeding was the constitutional validity of the acquisition of certain areas at Ayodhya Act 1993 and the maintainability of special reference number 1, the presidential reference made by the president under so and so, are the questions of decision herein. The background in which these questions are to be answered is contained in the facts stated in the white paper on Ayodhya, February 93, issued by the Government of India. Now I skip to the dissenting opinion because it is of great significance. It's authored by Justice Bharucha, who later on became the Chief Justice of India, and also Justice Ahmadi, who also later became a Chief Justice of India. In their dissenting opinion, authored by Justice Bharucha, he says, thirdly, para 151 of this reported judgment, there is the aspect of evidence in relation to the questions referred. It is not our suggestion that a court of law is not competent to decide such a question. It can be done if expert evidence of archaeologists and historians is led. and is tested in cross-examination. So it is the dissenting opinion which actually insists that a dispute of this nature should be decided on evidence of archaeologists and historians, which is how this case has been actually decided. On 1st August 2002, the High Court proposed that an excavation be carried out by the Archaeological Survey of India. The High Court proposed that before excavation, ASI will survey the disputed site using ground-penetrating radar or georadiology system. After objections to the proposed directions were heard, they were rejected by the High Court on 23rd October 2002. The ASI had a GPR survey conducted by a corporate entity which submitted its report to the High Court on 17 February 2003. The report found the presence of anomaly alignments across the main platform north and south of the Sanctum Sanctorum corresponding to the Ramchabutra area. So that was a preliminary study which was ordered by the High Court, taking cue probably from the dissenting opinion of the Supreme Court, and then they found that there were anomalies. So we go back to the pleadings. The pleadings of the Waqf board that this was built on a vacant land. So by the time this order was passed, the structure was demolished, there was a temporary temple, and there was a status quo which was operating. In this background, a GPR survey was done on orders of the court. Neither parties asked for it. And I'm told it's a matter of folklore or memory of bar that people were really worried कि अब क्या होगा अगर कुछ नहीं निकला तो. Because for us, it was a matter of faith for centuries, for generations. But when you want to test it on science, you're not sure what happens, because science is something which actually many people find to be antithesis to faith. I mean, if I can digress, there's a nice write-up on this, disharmony. I think only Sanatan actually is the only form of living which reconciles or which actually merges science and faith through rational thinking. And we have a tradition of Vada, Samvada, Jalpa, Vitanda through which we ascertain truth. So therefore, we have evolved mechanisms of finding out the truth about the creation, the creator, our own existence. And then we have evolved, our civilization has evolved over thousands of years. And this is documented through our Itihasas, our Upanishads, and recognized across the world. But unfortunately, our colonization has left a very deep impact on our minds, that we actually start thinking in a Stockholm Syndrome mindset. So we are not able to accept our own past realities, and we think more like what our masters want us to think as. Now, going back to the ASI, then there was an excavation ordered because they found there's a lot of evidence to actually probe further. And then there were orders passed to do that. In order to bring objectivity to the process and subserve the confidence of the parties, the High Court ensured that adequate representation to both the communities be maintained in respect of the functioning of the ASI team and the engagement of the laborers. During the course of process, the High Court considered various objections filed by parties with respect to the excavation. The ASI submitted its final report on 22nd August 2003, to which objections were addressed by the Waqf board and other parties. These objections were dealt by the High Court. Wealth of arguments have been urged on the archaeological evidence in present dispute. The arguments touch upon diverse issues such as findings in the report, the inferences, and have been drawn from them. Archaeology as an inferential science, as well as the value of archaeological evidence in disputes such as the present. This court must address inter alia the findings of the report, the methodology adopted, the objections raised, etc. So the scope of challenge to the Archaeological Survey of India report also was extensively gone into. And then there's a reference to the chapter 3 of the ASI report. Inter alia deals with stratigraphy, chronology. The report indicates the excavation has yielded a continuous cultural sequence involving depth of 10.80 meters. This can be divided into 9 cultural periods explained below on the strength of combined and corroborative evidences of pottery, sequences, structural remains, and other datable finds. The report indicates that structural activities in the excavated area had commenced from the Kushan period and continued in the Gupta and post-Gupta periods. Excavations have been made it aptly clear that the site has been successive structural activities which began from the middle of the Kushan level at the site. The brick and stone structures that were raised in Kushan and succeeding periods of Gupta and post-Gupta times have added heights to the mound. To build further structures upon the earlier debris, the later people added a deposit of earth excavated from the periphery of the mound, which belonged to the much earlier cultural periods. This is true for the rest of the structural phases also. The ASI report as stated above finds the existence of deposits of 9 cultural periods. These are period 1, 6th to 3rd century BC, 2nd century to 1st century BC Sunga level, 1st to 3rd century AD Kushan level, 4th to 6th century AD Gupta level, 7th to 10th century AD post-Gupta Rajput level, 11th to 12th century AD Sultanate level, 12th to 16th century AD medieval level, 8th century Mughal level, 9th late and post-Mughal level. So these are the levels on which. So one thing stands established that it was not a vacant land. Chapter 4 of the ASI report deals with structures. A significant aspect of this chapter is section titled The Massive Structure Below the Disputed Structure. Finally, the ASI concludes by indicating that now viewing in totality and taking into account the archaeological evidence of a massive structure just below the disputed structure and evidence of continuity in structural phases from the 10th century onwards up to the construction of the disputed structure, along with the yield of stone and decorated bricks as well as mutilated sculpture of divine couple and carved architectural members, including foliage patterns, amalaka, Kapotpali, Durjam with semicircular pilaster, broken octagonal shaft of black schist pillar, lotus motif, circular shrine having pranala in the north, 50 pillar base in association of the huge structure are indicative of remains which are distinctive features found associated with temples of North India. Initially, the case of the Sunni Waqf board was that the building in dispute was constructed at a place on which there was no existence of Hindu religious structure and there was no evidence to suggest that the structure was at the place which Hindus believed to be the birthplace of Lord Ram. Justice Agarwal noted that when the excavations progressed, there was marked change in the approach of the plaintiffs in suit 4 and a new case was sought to be set up. The structure below the disputed structure as shown in the excavation is of Islamic origin, namely either an Idgah or a Kanati Masjid. Justice Agarwal noted that this shift in stance of the Muslim parties clearly excluded the possibility of that the structure which was found below the disputed structure was of an origin which is not religious. The inquiry then narrowed down to whether the structure was Islamic or non-Islamic. So therefore, they agreed that it is a religious structure, either a mosque, Kanati mosque or an Idgah or something else. So that is what is narrowed down. It is clear, this is the Justice Agarwal's observation in the Allahabad High Court judgment. It is clear from the report that floor 4, which supports the foundations of pillar bases, was a floor of a temple. It cannot be the floor of Idgah or Kanati mosque because pillars are always absent in Idgah so that the maximum persons could be accommodated in minimum space for opening prayer. So this is basically understanding of what an Idgah or a Kanati mosque is. The conclusion in the ASI report about remains of an underlying structure of a Hindu religious origin symbolic of temple architecture of the 12th century must however be read contextually with the following caveats. While ASI report has found the existence of ruins of a pre-existing structure, the report does not provide the reason for the destruction of the pre-existing structure and whether the earlier structure was demolished for the purpose of the construction of the mosque. I am sure 500 years later, no evidence will be there to show Trump has bombed Iran, if ASI has to do a search without the data being preserved in a form that we have it today. So therefore, certain evidence will not be available. It is only an inference which is permissible or not permissible in law. So therefore, the test for a court is it a logical inference which can be sustained having regard to the corroborative material which is already on record independent of this material. So that is how preponderance of probabilities, the yardstick of evidence in a civil trial is actually put to action. Since the ASI report dates the underlying structure to the 12th century, there is a time gap of about 4 centuries between the date of the underlying structure and the construction of the mosque. No evidence is available to explain what transpired in the course of intervening period of nearly 4 centuries. Nobody was in dispute for this period. The dispute commenced with 1528. So therefore, there was no occasion for any party to lead evidence on this issue. Be that as it may, the ASI report does not conclude that the remnants of the pre-existing structure were used for the purpose of constructing the mosque. Apart that, is from the construction of the mosque on the foundation of the erstwhile structure. The pillars that were used in the construction of the mosque were black Kasoti stone pillars. ASI has found no evidence to show that these Kasoti pillars were relatable to the underlying pillar bases found during the course of excavation in the structure below the mosque. The finding of title cannot be based in law on the archaeological findings which have been arrived at by ASI. Between the 12th century to which the underlying structure is dated and the construction of the mosque in the 16th century, there is an intervening period of 4 centuries. No evidence has been placed on record in relation to the course of human history between the 12th and 16th century. No evidence is available in the case of the antiquity on the cause of destruction of the underlying structure, whether the pre-existing structure was demolished for the construction of the mosque. Title to the land must be decided on settled legal principles and applying evidentiary standards which govern a civil trial. So that's how the court has determined that there was a pre-existing structure and it stopped at that inference. And that structure was definitely a non-Islamic structure. And it had indications of a temple construction which is normally found in North India. Then we come to the arguments. Now, if you see what is the evidence that the parties have led prior to 1857. The admitted case of the Muslims, these are statements I have quoted from the Supreme Court judgment. Dr. Dhawan, learned senior counsel appearing on behalf of the plaintiffs in suit 4, admitted that there is no evidence of possession, use or offering of worship in the mosque prior to 1856 to 57. The previous slide we have seen, the court comes to a view that there is no evidence from 12th to 16th century. Now here we see till 1857, 56-57, they have no evidence of possession, use or offering of worship prior to 1856-57 when the artificial partition of a composite unit happened under the supervision of the British colonizers. No evidence has been produced to establish worship at the mosque or possessory control over the disputed property marked by letters ABCD or the period of 325 years between the alleged date of construction in 1528 until the erection of railing by the colonial government in 1857. Hence, in the absence of evidence on record, no conclusion can be drawn that prior to 1857, the disputed site was used for worship by the resident Muslim community. Following the events in 1856-57, the colonial government erected the railing to bifurcate the area of worship into inner courtyard and outer courtyard. Shortly thereafter, the Ram Chabutra was constructed in the outer courtyard. Worship at the Ram Chabutra and at the pre-existing Sita Rasoi led to the worship of the Hindus being institutionalized within the property marked by letters ABCD. So, two things happened. They have admitted they had no evidence prior to 1856-57. On the contrary, there has been historical documentation of travelers that from 1608 onwards that Hindus have been worshipping there. The case of the plaintiff in suit 4, which is the Sunni Waqf Board, has to be evaluated on the basis of the entirety of the evidence on record to adduce whether possession has been established on a preponderance of probabilities. The evidence reveals several significant features which must be noted. Though the case of the plaintiff in suit 4 is that the mosque was constructed in 1528 by or at the behest of Babur, there is no account by them of possession, use or offer of namaz in the mosque between the date of construction and 1857. For a period of 325 years which elapsed since the date of construction until the setting up of a grill brick, they have not adduced evidence to establish the exercise of possessory control. Evidence of worship of Janmasthan. Now I am contrasting. On the contrary, the travelers, chiefly Trifandalar and Montgomery, provide a detailed account both of the faith and belief of Hindus based on the sanctity which they ascribe to the place of birth of Lord Ram and of the actual worship by the Hindus at the Janmasthan. William Finch 1608-11 and Trifandalar, who visited India between 1743 to 1785, provided an account of Ayodhya. Conspicuous in both accounts are references to worship by the Hindus to the Lord Ram. The existence of reference to worship is there. Inner courtyard and outer courtyard. Now, when does this bifurcation happen? The communal rights that took place in 1856-7 resulted in the colonial administration setting up a grill brick wall to bring about a measure of peace between the conflicting claims of the two communities. The immediate aftermath of the railing led to the dispute over the Ram Chabutra, which was erected right outside the railing and from where the Hindus sought to offer worship to Lord Ram. If you see, the orange portion is the central dome and the marked portion in the grey band, that is the railing, the iron railing which bifurcated. The yellow portion is the outer courtyard, which was given access to the Hindus, and the inner courtyard is where they were restricted. So the 1480 square yards now is split into 740 each or something like that. That's how this portion was being enjoyed from 1857. Prior thereto, the Hindus had full access till the central dome. 1857, post 1857, continued worship. The time of setting up of the Chabutra, the place of its location, and the offer of worship to Lord Ram on Chabutra are pointers in the direction of the Hindus continuing to offer worship immediately outside the railing when faced with a possible exclusion from the inner courtyard. In fact, there was a question asked. So, what were they worshipping when they came to the railing? Why were they looking inside from the railing? Because many depositions came and they said that they stood outside the railing and were looking into the central dome. So, people who are familiar with the South Indian Agama temples, the sanctum sanctorum is not accessible to devotees. So, you have to stand out and have a worship of the main deity from outside, unlike in Kashi Vishwanath or Ujjain, where you may have access to the primary deity itself. So, that is the difference between the worship forms. So, people of Hindu faith are used to both forms of worship. They either get access to the sanctum sanctorum, or even if they don't have access to the sanctum sanctorum, they worship from a distance. In fact, for me as a South Indian Telugu, we have a concept of Gopura Darshana also. So we can't go to the temple, we just prostrate to the Gopuram of the temple and then worship from a distance, which is a symbolic worship of the deity under it. Until 1877, there was only one entry through which access could be gained to the inner courtyard, and which was the door on the eastern side called Hanuman Dwar. On gaining entry, the Hindus had several places of worship such as Ram Chabutra, Sita Rasoi as well as Bhandara, which indicated insofar as the outer courtyard is concerned, the Hindus were in settled position. Disputes between the Hindus and the Muslims continue to persist, indicating the litigious nature of the respective claims in respect of the inner courtyard. So therefore, there was no claim asserted by the Muslims for the outer courtyard. They restricted their claims to the inner courtyard now. Historical records of travelers, chiefly Tiefenthaler and the account of Monk Very Martin in the 18th century indicate the existence of the faith and belief of the Hindus that the disputed site was the birthplace of Lord Ram. Identifiable places of offering worship by the Hindus including Sita Rasoi, Swargadar and the Bedi, symbolizing the birth of Lord Ram in and around the disputed. So there were symbols in the outer courtyard where people used to worship. Prevalence of the practice of worship by pilgrims at the disputed site, including by parikrama, and the presence of large congregations of devotees on the occasions of religious festivals, and the historical presence of worshippers and the existence of worship at the disputed site even prior to the annexation of Awadh by the British and the construction of a brigade wall in 1857 are all established on records. The Muslim account of worship prior to 1856 is conspicuously silent, opposed to the accounts of worship being offered by the Hindus post the setting up of the wall and railing. Suit of 1885. The suit of 1885 was instituted by Mahant Raghuvar Das. If you could just recall the first suit onwards, the Muslims have been referring to this suit. Mahant Raghuvar Das, describing himself as Mahant Janmasthan situated at Ayodhya. The suit was initially instituted only against the Secretary of the State of India. The plaintiff averred that the place of Janmabhoomi is ancient and sacred and is a place of worship for the Hindus. The plaintiff claimed to be Mahant of this place of worship. The Chabutra Janmasthan was described as admeasuring east-west 41 feet and north-south 17 feet. It was pleaded that there was a Charan Paduka fixed on it and that there was a small temple which was worshipped. The plaintiff claimed to be in possession of the Chabutra. The plaintiff averred that he and other fakirs were inconvenienced in inclement weather and that the construction of a temple on the Chabutra would not cause harm to anyone else. So in the outer courtyard, he wanted to build a temple. That was his suit. However, it was stated that the Deputy Commissioner of Faizabad had opposed the construction of the temple, and despite a notice, the government had not taken any action. The basis of the claim was that a subject has a right to construct a building on land which is possessed and owned by him. The Muslims were originally not impleaded as parties to the suit. Muhammad Asghar, in his capacity as a Mutawalli, applied to be impleaded and was made a party. In his written statement, Muhammad Asghar set up a plea that the mosque was constructed by Babur. He stated the ownership could not be claimed by plaintiff who had not produced any material originating in the emperor or the ruler of the time in support of his pleas. मतलब कागज नहीं दिखाया. That was their claim, that Mahant has not shown any paper of title. The plaintiff had no title to the Chabutra. Ingress and egress for the purposes of worship does not prove ownership. The Chabutra came up in 1857. Construction of Chabutra did not confer any right of ownership, and new construction on it had been restrained by government, as a result of which a hut which was set up by Fakir had been demolished. It was argued that the spot was disputed between Hindus and Muslims, resulting in communal incident. The findings are: in his judgment dated 24th December 1885, the subject at Faizabad accepted the position and ownership of the Hindus of the area surrounding the wall of the Masjid. However, the subject held that if the permission for construction of the temple were granted, the serious situation endangering law and order would arise between the two communities. The subject held, over and above this, on the temple situated on the Chabutra, an idol of Thakurji is kept which is being worshipped. The Chabutra is in possession of the plaintiff, and whatever is offered on it is taken by the plaintiff. The possession of plaintiff is proved by witnesses. For the plaintiff, and railing wall separating the boundary of Hindus and Muslims exists for a long period. In the year 1855, after the quarrel between Hindus and Muslims, a wall in the form of railing was erected to avoid controversy, so that Muslims may worship inside it and Hindus may worship outside it. So the outside land with Chabutra, which is in the possession of the plaintiff, belongs to Hindus. Though this place where Hindus worship, they hold its position since old, because of which there cannot be objection to their ownership, and the area surrounding around the wall of the Masjid and the outer door word Allah is engraved. Despite the above findings on the occasion on possession by and ownership of the Hindus, the suit was dismissed because a serious breach of law and order was apprehended. In appeal, the judgment of the trial court dismissing the suit was affirmed by the district judge Faizabad. The district judge held that while it was unfortunate that a mosque has been constructed on land held sacred by the Hindus, an event which had occurred over 3 centuries earlier could not be remedied. It is most unfortunate, this is a British judge, that a masjid should have been built on land specifically held sacred by the Hindu, but as that event occurred 356 years ago, it is too late to remedy the grievance. All that can be done is to maintain that parties in status quo. I assume none of the political parties of the day were in existence when this order was passed. These findings were written. The judgment of the first appellate court was carried before the Judicial Commissioner Raud in second appeal, who affirmed the dismissal of the suit on 2nd November 1886. The Judicial Commissioner observed, the Hindu seems to have got very limited rights of access to certain spots within the precincts adjoining the mosque, and they have for a series of years been persistently trying to increase their right and to erect a building over 2 spots in the enclosure, Sita ki Rasoi and Ram ki Janmabhoomi. The executive authorities have persistently repressed these encroachments and absolutely forbid any alteration of the status quo. Now, the reasons why this judgment was not accepted to be binding on the Hindus. Parties are different. Neither the deities, the plaintiff in suit, that is Ram Lala Virajman, nor the Sunni Central Waqf Board, the plaintiff in suit, were parties to the suit of 1885. The suit of 1885 was not instituted by Mahant Raghuvar Das in a representative capacity. So he was not representing anyone except himself. The suit properties are distinct. The suit of 1885, the subject matter is only the Chabutra measuring 17 into 21 feet, and in the present proceeding, the suit property in both suits 4 and comprise of the inner and outer court triad. So therefore, that was the distinguishing factor. The pleadings and the findings in the earlier suit of 1885 show that Mahant Raghuvar Das was only asserting right that was personal to him. The earlier suit was not instituted in a representative capacity. The issues framed, the reliefs sought were distinct, and so were the suit properties. Where is Janmasthan? Now finally we reach this question. Mr. Jilani, learned senior counsel appearing on behalf of the Sunni Central Waqf Board, has nuanced response to the submissions which are founded in the religious scriptures. Mr. A. N. Mishra had counted. There is no reference to Ram Janmabhoomi site either in Valmiki's Ramayana or in Ramcharitmanas. The religious scriptures contain no reference to Ram Janmabhoomi temple or Ram Janmasthan temple. The submission which has been urged is that there is no dispute about the faith and belief of Hindus. The Lord Ram was born in Ayodhya, but the Janmasthan temple which has been worshipped lies to the north of disputed site. So therefore they admit there is a Janmasthan which is on the northern side. Moreover, it has been stated that after 1855, the Chabutra in outer courtyard was worshipped as the place of birth. Hence, according to Mr. Jilani, there is no evidence of the area below the central dome being worshipped as a place of birth of Lord Ram before the dispute over the site which arose in 1949. So what they are saying is, in 1950 also in the written statements, that the Janmasthan is probably across the road on the northern side. Now they say because of the finding in 1885, it is come inside the main composite building, but it's outside, outer courtyard. So it's a matter of few yards apart that they're not arguing about a Janmasthan of Lord Ram. Both Dr. Rajiv Dhawan and Mr. Jilani contested the claim of the Hindus that the place under the central dome of the disputed structure represents the birthplace of Lord Ram. The evidence of the above witnesses was relied upon Mr. Jilani to submit the scriptures do not contain a reference to the site called Ram Janmabhoomi. There is no reference in the scriptures to Ram Janmabhoomi temple or Janmasthan temple, and there is an absence of evidence that the place below the central dome was worshipped prior to 1950 by the Hindus as the birthplace of Lord Ram. Mr. Jilani submitted that after 1855, the Chabutra was being worshipped as the place of birth of Lord Ram, which belies the notion that the place below the central dome was believed to represent Lord Ram's birthplace. So when this matter was being argued and these arguments were addressed, a certain reporting happened that they have conceded that it is outer courtyard. So the next day, Mr. Jilani had to clarify that this is a finding which has not been assailed by anybody, and therefore Ram Chabutra is being accepted as a Janmasthan. On his analysis of the gazetteers and travelogues during the course of the submission, Mr. Jilani formulated the following proposition. For the period dating from the construction of the mosque in 1528 until 1949, there is no evidence to establish the belief of the Hindus that the place of birth, Lord Ram, was below the middle dome of the mosque. There is no evidence to show continuity of worship inside the mosque onwards of 1828. Ram Chabutra is birthplace of Lord Ram. Ram Chabutra's birthplace is corroborated by the fact that in the suit of 1885, the plaintiffs sought no prayer with respect to the intercourtyard. That should be 1528, not 1828. It was only in suit 5 of 89 that the concept of a Janmasthan was introduced, prior to which the belief that the central dome was the birthplace of Lord Ram did not exist, and the theory of the middle dome marking the birthplace of Lord Ram only comes from the statements of the witnesses in suit 5, which is filed in 1989. The formulation of Mr. Jilani that Ram Chabutra is the birthplace will assume significance from two perspectives. The first is that the entire site comprising of the inner and outer courtyards is one composite property. The railing being put up by the colonial government only as a measure to protect peace, law and order. The second perspective is that Mr. Jilani's submission postulates the acceptance of the position that the birthplace is at an area within the disputed site. The Ram Chabutra, according to him, and there is no denying the close physical proximity of Ram Chabutra, which was set up right outside the railing. Dr. Rajiv Dhawan, learned senior counsel appearing on behalf of the plaintiff in suit 4, urged that any use of historical material consisting of travelogues and gazetteers should be prefaced with caution. Dr. Dhawan urged that issues of title cannot be decided on the basis of historical work, treatises and travelogues. The court ought not to pursue the line of approach read out by counsel for plaintiff, who attempted to draw inferences on the basis of untested historical material. History cannot be read or interpreted without recourse to historiography. In fact, this is when I heard the word historiography for the first time in my life. I've inquired with my friends in Delhi University also who did their BA History Honours. They are not taught historiography. Because in India, the academic space teaches only history and not historiography, I believe, because the only history we are taught is Marxist history. There is no space for other forms of history, and historiography is the science of the historian's method of writing history. So there is a Marxist history, there is an Oriental history, there is a nationalist history. So there are various methods where people actually have chosen their priority in documenting history. So that methods are very critical to understand. It's like knowing which channel you're watching to assess the weight you need to give to the opinions. This is as simple as that. Now the verdict. The Hindu witnesses to whom a reference has been made earlier have furnished statements of their faith and belief in the place under the central dome being the birthplace of Lord Ram. The witnesses explained the basis of their belief by interpreting the text of the scripture, Ayodhya Mahatmya, Valmiki Ramayana, Ramcharitmanas. The cross-examination of the witnesses has not established any basis for the court to be led to the conclusion that the faith and belief of the Hindus as portrayed through these witnesses is not genuine or that it is a mere pretense. Matters of faith and belief lie in the personal realm of the believer. That which sustains solace to the soul is inscrutable. Whether a belief is justified lies beyond ken of judicial enquiry. This is not a case where the witnesses' statements indicate that the belief or faith is a veneer or that it is being put forth merely as a strategy in litigation. This is not a piece of land where you seek to encroach by putting up some place which is revered in particular faith and then have shops or commercial establishments mushroom around it to encroach public property. So this is a case where for hundreds of years, independent travelers have observed the practice of faith being there, independent of all obstacles being put forth by the rulers of the time, including the colonial rulers. Once the witnesses have deposed to the basis of the belief and there is nothing to doubt its genuineness, it is not open to the court to question the basis of belief. Scriptural interpretations are susceptible to multitude of inferences. The court would do well not to step into the pulpit by adjudging which, if any, of competing interpretations should be accepted. Faith is a matter for the individual believer. Once the court has intrinsic material to accept that the faith or the belief is genuine and not a pretense, it must defer to the belief of the worshipper. This we must do well to recognize applies across the spectrum of religions and their texts. Hinduism and Islam being among them, the value of a secular constitution lies in a tradition of equal deference. The evidence indicates that despite the existence of a mosque at the site, Hindu worship at the place believed to be the birthplace of Lord Ram was not restricted. The existence of an Islamic structure at a place considered as sacrosanct by the Hindus did not stop them from continuing their worship at the disputed site and within the precincts of the structure prior to the incidents of 1856-57. The physical structure of an Islamic mosque did not shake the faith and belief of Hindus that Lord Ram was born at the disputed site. On the other hand, learned counsel fairly stated that evidence relied on by the Sunni Waqf board to establish offering of namaz by the Muslim residents commences from 1856-57. Or about 1877, at the behest of the Hindus, another door to the outer courtyard was also allowed, and then a new door was opened. So these are all the material which we have already considered earlier. After the construction of the brick wall, there is an evidence on record to show exclusive and unimpeded position of the Hindus and the offering of worship in the outer courtyard. So therefore, the court now is asserting access of worship to the Hindus in continuum over a period of centuries. The net result as it emerges from the evidentiary record is that the disputed site is one composite whole. The railing set up in 1856-57 did not either bring about a subdivision of the land or any determination. The Sunni Central Waqf Board has not established its case of a dedication by user. The alternate plea of adverse position has not been established by the Sunni Waqf Board as it failed to meet the requirements of adverse position. The Hindus have been in exclusive land, unimpeded position of the outer courtyard where they have continued worship. The inner courtyard has been contested site with conflicting claims of the Hindus and Muslims. The existence of the structure of the mosque until 6 December does not admit any contestation. The submission that the mosque did not accord with Islamic tenets stands rejected. The evidence indicates that there was no abandonment of mosque by Muslims. Namaz was observed on Fridays toward December 49, the last namaz on 16th. The damage to mosque in 34 and desecration in 49, leading to ouster of Muslim and eventual destruction, constituted serious violation of rule of law. Consistent with principles of justice, equity and caution, both suits have to be decreed. The Hindus have established a clear case of possessory title to the outside courtyard by virtue of long continued unimpeded worship at the Ram Chabutra and other objects of religious significance. The Hindus and the Muslims have contested claims to offering worship within the three-domed structure in the inner courtyard. The assertion by the Hindus of their entitlement to offer worship inside has been contested by Muslims. On the balance of probabilities, there is clear evidence to indicate that the worship by the Hindus in the outer courtyard continued unimpeded in spite of setting of brick wall. The position of the outer courtyard stands established together with incidents attaching to their control. Position of inner and courtyard shall be and over to the board of trustees of the trust or the body to be constituted. The central government will be at liberty to make suitable provisions in respect of the rest of the acquired land by handing it over to the trust or body for management and development in terms of the scheme framed in accordance with the law. Well, with this we come to the conclusion of this judgment, and the quote that I chose to put up is of Justice of eminent jurist Nani Palkhiwala. It's so inspiring. I read this many decades ago. While I think of the future of India with a great deal of concern, the concern is not tinged with despair. I like to act on the principle pessimism of the intelligence, optimism of the will. India has the gist of producing great souls in the darkest hour. It should not be sold, it should be soul. In the darkest hour, I have a deep-seated faith that when that hour strikes, someone is born. I think that summarizes the spirit of India. When we were subjugated for centuries, when we subjugated physically, colonially, by all kinds of challenges, the spirit didn't die. The will to fight didn't die. And that even today is a most inspiring thing that we can have for ourselves as Indians, as proud Indians who take pride in our culture, in our civilization. And I couldn't come across someone more proud of our civilization than eminent jurist Mr. Palkhiwala. I happened to read his works and then found the kind of pride he has in his writings. And I think I commend that anyone who gets an opportunity should read his works on Indian heritage, culture, etc. Bharati Vidyavan has published some of these booklets, various talks he's given, pre-emergency, post-emergency, amazing insight that he gives, which is so relevant even today. This is a case where our cultural civilizational identity was actually put on trial. Our faith, being not a pretense, was put on trial, because what we were told, and I believed it, I bought that argument as much till 2017 when I got involved in this case, that this was a political battle which is commenced probably by the political parties of the day. So, but when I got into the matter by providence in 2017, started reading the records, then I suddenly realized the pleadings of 1950 talk about 1885 case. So, none of the political parties of today were in existence. So, how does it become a political issue in 1885, in 1856, 1857? And then what does the traveler in 1608 find to do with the current politics? So, therefore, this is something much deeper, and we've been completely misled, deliberately and mischievously, to not understand the depth of this battle, which was fought in accordance with the mandate of the Constitution by leading evidence in a jurisprudence which is alien to our Sanatan, because our faith is practiced in a particular form, but we had to approach the litigation in a form which is completely dependent on a Western approach of jurisprudence, common law principles, adverse position, and then we, as the trial proceeds, we can see how things reveal themselves. And I believe truth always prevails, satyameva jayate. And one thing I cannot miss in this case is that people of faith, whatever be their faith, stood by truth. People who have their allegiance to amoral ideologies have nothing to do with truth. They always wanted to delay any dispute being resolved. Their investment or capital is in having some kind of a destabilizing aspect which is promoted by their ideological moodings. So unfortunately, that kept this pot boiling for too long. If you go for a trial, the matter would have been over, not in 70 years, probably in 7 years. So why did this trial take 70 years is a question that we should ponder over. What delayed the trial? Who delayed the trial, and what was the need for the historians to lie? And there's like reams of paper of evidence which has come about later, and authentic publications on our history which has now come about, where the role played by the mythologists who call themselves historians has been exposed. I think I have not spent much time on the archaeological because Mr. K.K. Mohammed has spelled out the details on the archaeological aspects in detail. So leave aside the court proceedings, the evidence law, the procedural law. Why is it that our civilization is under this kind of a challenge even today in a constitution which gives us our freedoms? And why is it that we are not able to assert our constitutional rights in accordance with the constitutional remedies is something we should ponder over. With these thoughts, I thank the organizers and I thank Parasaranji for being so gracious to have allowed me to work with him on this case, and of course my colleagues Niharika and Chamundeshwari who helped me prepare this presentation. Thank you very much. Thank you.
I mean, the reason we wanted this is because in the Muslim circles, they still keep saying that, oh, there was no evidence and the Supreme Court ruled and all of that. No. So there isn't enough in Lehman narratives, there isn't enough understanding of the case. This is why I late though, but I thought it'd be good to cover this. Question: could the temple have been built had the mosque not been demolished?
No, the Suit 5 has been decreed. Suit 5 was for recovery of possession and to build, remove the structure and build a temple, and it has been decreed.
Oh, so if the mosque had not been demolished, it would still have been demolished after?
No, the evidence leads only one way, sir, in a civil suit. So, and then because of the continuous position and the manner in which during the pendency of the proceedings, the structure has been brought down, they've been wronged in 1949 to have desecration. The court felt it was important that that suit is also decreed and an alternate site has been given to them to assuage harmony in the society in exercise of their power under Article 142.
Just for clarity, it would have been demolished?
Suit is decreed. That's what I read.
Oh, yeah.
Suit is decreed.
Okay. And why was the alternate land given at all?
See, I mean, there's a principle of fraternity that we always practiced in this land, even before the French Revolution. So, I think people of faith, not people of ideology or people of political agendas, people of faith believed and went and worshipped to their God in the premises, in the faith that that was built on a vacant land. So, to respect the faith of the truthful is what probably a constitutional government would do. And in fact, for Ram, everyone is inclusive. For Sanatan, there's no other, there's no heathen, there's no kafir. For us, everyone is ours. It's a form of life, be it a tree or a species of any form. It's part of the journey of the Atma before you come out of the cycle of birth and death. So therefore, for us, there is no other. But unfortunately, people find us as others or heathens or kafirs. It's their problem. So I think in that spirit, I don't see any difficulty with this order.
You alluded to this in your concluding remarks, but we are told that the Muslim side always knew that they would never win this case. Had it not been for Marxist historians, this case would have concluded, like you said, perhaps in 7 years instead of 70. Any comments?
I think we always believe वक्त से पहले और किस्मत से ज़्यादा कभी कुछ नहीं मिला है. So the time had to come and Parasaran ji had to address the court and lead us into the new horizon of revival of our civilizational battle.
Okay. And finally, so the concluding, the judgment was basically basis the archaeological evidence. Would that be accurate to say?
Yes, because
there was an underlying temple?
Absolutely. See, the premise of a vacant land is demolished. The admissions repeatedly that there is no evidence of dedication of a Waqf, of building of the Masjid, much less an offer of namaz prior to 1857. On the contrary, the preponderance of probabilities of multiple travelers who had nothing to do with the dispute recording the worship there. The practice of superstition is how the Jesuit travelers called, of actually doing the pradikshina around the temple or the Janmasthan. So those practices all lead to this conclusion. In fact, as many of the Muslim witnesses also in trial as well, because of paucity of time, we couldn't really get those evidences also accepted, where they say that some of them, in fact, in the written statement say that if you find that it was built on a temple, we'll hand over the land in written statements. So those statements were also there in trial. So therefore, as far as people of faith is concerned, because if I am a true believer of my faith, I will not accept which is prohibited my faith, because then my faith is fake. If I worship a formless form of the creation, how do I go and offer my prayers in the presence of forms? It's actually an oxymoron. So therefore, this has come about only because of the political aspect of probably some agenda which was driving this litigation and keeping it pending to deny truth. So the Marxist professors who claim to be historians, archaeologists, in cross-examination, I refer to the dissenting opinion of Justice Bharucha and Ismail Farooqi. He says that when you're tested on cross-examination as a historian archaeologist, the truth would emerge. And they were tested on cross-examination, the truth emerged about their writings being nothing to do with the reality on ground or any credible research. Thank you very much.